Hey friends, if you're interested in hearing 6 creative ways that folks get their green card through a relative, watch this video. I'm Latoya McBean Pompey, an immigration lawyer in New York, helping clients all over the US and all over the world be together in America. Contact us at McBean Law at 516-866-3900 or visit McBeanLaw.com to book your consultation. For those of you who have not yet subscribed to McBean Immigration TV, go ahead and do so right now, and then also hit the notification bell so that you'll be the first to be informed of my videos each week. I'm continuing my series on how to get a green card if you've overstayed your visa in America. If you've entered into the United States with a visa and you've overstayed the time that you're here, obviously the first thing really on your mind is, well, how can I get a green card? How can I get that legal status that I need so that I could settle down and feel free to thrive in America and have my family here with me? In my first 2 videos on this subject, I talked about the US citizen spouse, and then I also talked about getting a green card through a US citizen adult child. Now we're going to talk about some other ways that you can get the green card. Firstly, through a US citizen parent. Now, this gets a little tricky. It gets tricky because it all depends on the age of the child that is being petitioned for. If the child is under 21 and unmarried, that child is an immediate relative of a U.S. citizen, and therefore they could stay right here in the United States and get their green card through adjustment of status. However, if the child is 21 or over, that presents some significant problems if the child, right, the adult child is still here in the United States past the time that they were supposed to stay here. What is most significant with respect to the adult child is whether or not that adult child has unlawful presence on his or her record. If they do have that unlawful presence, and I'm sure most of you watching this video who have U.S. citizen parents, you understand this, maybe, I don't know, but with the unlawful presence on your record, it prevents you from seeking adjustment of status. You would have to go back to a U.S. embassy in your country to be interviewed for the immigrant visa and then come back in the U.S. and have your green card be sent to you, be mailed to you. However, you should not leave the United States unless you have a waiver approved, the I-601A waiver for unlawful presence. That needs to be approved before you finish the consular process with the National Visa Center and then go back for an interview. If the parent is a green card holder parent, that parent is also able to petition for either a child under 21 or a child over 21. The biggest difference between the U.S. citizen parent and the green card holder parent is that with the green card holder parent, that child cannot be married, okay? The green card holders are not eligible to petition for adult married children. Now, the green card holder child who has overstayed in the United States will need to consular process regardless of their age. They can be 10, they could be 16 or 15. They still will not be allowed to adjust their status in the United States through a green card holder parent. The key with this process is this, guys, and I want you to listen very closely to what I'm about to say next. The age of the child, the green card holder child, makes a significant difference because if the child is 18 or over, that child has started to accrue unlawful presence on his or her record unless that child had a non-immigrant visa that allowed that child to maintain a lawful status in the United States. However, if the child did not have that continuous lawful status in the United States through another visa, then that child must get the waiver approved before they leave the country. Otherwise, they could be stuck outside of the United States. The other way that people can get a green card is actually through a relative, such as an aunt or a grandparent. However, and I get this question a lot, can I, file for my granddaughter or my niece or nephew? And generally the answer is no. There is no category that's in our system that allows for that type of filing unless the child was legally adopted by that grandparent or by that aunt, and the child must have been at a certain age at the time of the adoption, and the adoption must not be for immigration purposes. Okay, so keep that part in mind. The third way that people can get a green card through a relative is if the spouse or parent has a non-immigrant visa, like H-1B visa, and then that parent or spouse ultimately gets a green card through their employer. Now, the fourth way that people can get a green card after overstaying their visa is if they were a K-1 visa holder. They entered into the country with that K-1 visa with the intent of marrying their petitioner within 90 days. However, they didn't marry that petitioner. They ended up marrying someone else. And guys, this does happen. And then for many of those people, they get stuck because they cannot adjust their status. But there is a way for those individuals to still get the green card, and it's through consular processing by going back to a U.S. embassy. However, if they've overstayed in the country, again, they will also need the I-601A waiver. The next way is through a U.S. citizen sibling. And the sibling process can be very frustrating for a lot of people because they've waited for many years for this process to work, and then ultimately to find out that, wait a minute, I actually need a waiver and I have to go overseas because I've been in America all this time and I was waiting on this process and working or doing other things. So if you are here in the US and you have a US citizen sibling who filed for you, you're going to need a waiver and consular processing. However, if you're overseas, then you will go straight to your embassy process and get your immigrant visa that way. Now, lastly, the other way that people can get a green card is if they came into the United States under the Conditional Resident Immigrant Visa. And those individuals get a 2-year green card once they come into the United States. Now, for some people, once they come into the United States, they have marital problems or whatever the case may be, and they separate or get a divorce from the person who actually petitioned for them. And those individuals are still able to get their 10-year permanent residency card by applying through a process that we do in our office for our clients as well. And it's a waiver process to get that 10-year green card. This is not it, guys. I want you to know that there are other ways. This is not it, but I wanted to summarize these more common ways for you so that you could get some ideas. And if you fall into any of these categories, you should definitely reach out to us so that we could help you at McBean Law. I hope you found this video helpful. Share it with other people. Let me know your thoughts below. Don't forget to subscribe and hit the notification bell. And guys, I will see you in the next one. Bye-bye.